Federal law obligates employers to bargain with a union representing an employee majority. Generally, employees choose a union through an election. But National Labor Relations Board versus Gissel Packing Company shows another way to create a bargaining obligation. A union obtained signed authorization cards from an employee majority at Gissel Packing Company. The cards clearly stated that signing employees designated the union as their collective bargaining representative. Gissel refused to bargain with the union, instead interrogating individual employees about their union support, promising better benefits than the union could provide, and firing employees involved with the union. Another union obtained unambiguous authorization cards from an employee majority at Sinclair Company. When Sinclair refused to bargain, the union requested an election. Sinclair's president told employees that the company was financially fragile, that the union would likely strike, and that a strike would cause the plant to close. He warned employees that because of their age and skills, they wouldn't find new jobs. Sinclair distributed publications repeating those messages, and the union lost the election. Both unions filed charges with the National Labor Relations Board. In Gissel's case, the board found the cards valid and ordered Gissel to bargain with the union, concluding that Gissel had refused to bargain in bad faith and committed multiple unfair labor practices. On appeal, the Fourth Circuit sustained the board's conclusions regarding unfair labor practices, but refused to enforce the bargaining order, holding that cards were inherently too unreliable to establish majority support for the union. The board found that Sinclair had also committed unfair labor practices and set aside the election, finding that Sinclair's statements constituted threats so coercive that only a bargaining order could remedy their effects. The First Circuit affirmed. The United States Supreme Court granted cert in both cases and consolidated them with two similar cases.